Todd Frahm with Tyler Law LLP, and I just wanted to welcome you here today and thank you for joining. Today's topic is going to be everything a real estate agent needs to know about for-profit corporations in California. And for the next 10 to 15 minutes, I'll show you exactly how to confirm who can sign on behalf of a corporation, which documents to request and review, and how to avoid those last-minute issues that seem to always delay closings or jeopardize commissions. And this is, as always, general information for California practice and is not legal or tax advice. For the specific deals, make sure that you involve counsel early. So the first question is, why do corporations even matter to a real estate agent? Well, number one, corporations are everywhere in California real estate. They buy, sell, lease, manage, and guarantee obligations. And for agents, this means three things. First, you have to confirm the corporation's identity and good standing. Second, you have to verify the signer's authority. Title alone is never enough. And third, you have to align the corporate name, the signer's title, and the signature blocks across the contract, escrow, and recorded documents. And doing these three things early will protect your timelines and your commissions. As far as the basics of corporations, a California corporation is formed by filing articles of incorporation with the state of California. That's with the Secretary of State's office. The corporation is then governed by its bylaws and a board of directors. And the shareholders or the owners of the corporation elect those directors, and the board authorizes the major transactions. The officers, like the president, you might hear president or CEO, the CFO or treasurer, or the secretary, they can execute documents under authority granted by the board and the bylaws. For foreign corporations and those which are that is those which are formed outside of the state of California, they have to qualify to do business in California to stay in good standing in their home state and here. And so the takeaway really is that material real estate deals typically require board authorization and not just an officer's say so. When a corporation is your buyer, seller, landlord, tenant, or guarantor, ask for these documents up front. First, a Secretary of State entity search printout showing the exact legal name, their status as active, their entity number, and their state of incorporation. Second, the articles of incorporation and any amendments to confirm the existence and the name history. That can also, in most cases, except in the case of older corporations, that can be found on the Secretary of State's website. Along with third, you would need to get a copy of the bylaws, or at least those sections on officer powers and signing requirements, because some bylaws are going to even require 2 officer signatures or 2 directors, something like that. Fourth, a board resolution or a unanimous written consent authorizing this specific transaction and naming the signer or signers. Fifth would be a Secretary of State certificate or incumbency certificate confirming the current officers and attaching the authorized resolution. And then also certificates of good standing from California. And if it's a foreign corporation, from the home state as well, usually dated within 30 to 60 days of the transaction. And if there's a parent corporation involved as a guarantor, add the parent's resolution authorizing the guarantee. The step-by-step process here is going to be, number one, confirm the entity. Check the Secretary of State website for active status and an exact legal name, and confirm that the corporation isn't suspended by the Franchise Tax Board. Suspended corporations cannot close on transactions. They can't sue or defend in California. They're essentially blocked from taking any legal actions while they are in suspension. So you need to make sure of that. Step 2 would be to confirm the officers. Use the Secretary of State would have a statement of information on their website. We will put up a link for their the website. Make sure you run a search of that. Again, there you can normally find the articles of incorporation and the latest filed statement of information. which in the case of a for-profit corporation is required to be filed annually, and that would list who the current officers are of the organization. If they don't have one, it's definitely an issue. You need to make sure that there's one that's been filed. Third, you're going to want to get a transaction specific authorization, and the board resolution would identify the property, the price or the rent, as the case may be, the other party, the escrow or title company to be used, and the name of the authorized signer or signers. And then step 4 would be to make sure that the signature block is correct, that it reflects the corporation's exact name. You don't want a situation where it's like, hey, we call this thing, by shortened name, for instance. If it's, ABC Corp and their legal name is ABC Corporation, that's the proper name, and that's the name that needs to be used in all of your documents. So you're also going to want to make sure that you're identifying the signer correctly by their position and with the correct title. If the bylaw does require 2 signatures, for example, one from the president and one from the secretary, make sure you get both, and that you obtain I guess in an alternative, or you obtain a board resolution expressly authorizing a single officer to sign for this deal. And then step 5 would be to pre-clear all of this with your title and escrow. Always work with them. Make sure that they know what's going on. They've seen the documents, and that's one of the best things you can do to ensure that there are no surprises at closing. So how does a corporation sign? One example would be, for example, ABC Corporation, comma, a California corporation by Jane Doe, comma, president. We'll put these things up here for you, but if the officers, if the bylaws require 2 signatures, for instance, you would just add on that saying, by Mark Lee, comma, secretary. Example 2 is when a subsidiary is the title holder and the parent officer is signing, make sure that that person is also an officer or of the subsidiary or has a clear delegated authority from the subsidiary, and that the board resolutions support that. Okay, so keep the capacity clear on the signature line and consistent across the purchase agreement and any amendments, escrow instructions, and then obviously any deed or memoranda. That's pretty good, simplified process that you should go through on making sure you're working with the proper people. But, red flags are going to pop up, and some that you should watch for would be no resolution from the board at all, or a really vague resolution that doesn't name the property, the price, or the signer. And if that's the case, then you need to make sure that you require a transaction-specific board consent or ratification before you proceed at all. Number 2 would be the signer's title on the contract doesn't match the statement of information. The statement of information says Jim Smith, and the guy's name is actually James Smith Jr. Well, that needs to be updated. You either need to get an updated statement of information, and if needed, a fresh resolution on that. Number 3 would be, a foreign corporation that hasn't qualified to do business in California, or a name mismatch between the contract and the Secretary of State's records. So you're going to want to make sure that you get that all corrected. If they've done a name change, it's fixable, but you would also need to use, a formerly known as kind of designation with supporting evidence. Another red flag is if it's showing, this is a huge red flag, if it shows up as FTB suspended or SOS suspended, that either means that they are suspended by the franchise tax board, typically for failure to pay their annual franchise fee, or if they're Secretary of State, SOS suspended, that typically means that they failed to file or timely file their statement of information. Either way, you need to make sure that you get a reinstatement before signing, because title is generally going to refuse to insure while they're suspended. 5th would be if the bylaws were to require 2 signatures but only one is provided. So you're going to need to make sure you get that second signature, obviously. So, here's where authority and paperwork show up in your day to day. In a listing agreement, confirm that the corporation has the authority to engage your broker and to pay commissions. Make sure a duly authorized officer signs all of the documents. And then in purchase and sale agreements, use the exact corporate name, the state of incorporation, include authority representation, and add deliverables like the board resolution or secretary's certificate, or in the case of the foreign corporation, which is not yet qualified to do business in California, the qualification to do business in the state of California as a condition to closing the transaction. For leases, make sure that you're confirming landlord and tenant authority, any required guarantees, that the signer has capacity for build-out approvals, insurance certificates, indemnities, and then in your in your commission instructions, name the correct paying entity and get wiring instructions from an authorized corporate officer, and then make sure that the W-9 matches the payee name. So in California, there's some additional things like that get added in this. Not surprisingly, in California, there's always a few extra twists that you should flag early. The first would be that accuracy really matters. So use the exact corporate suffix. For instance, if their name is ABC Inc., INC, period, use that. If it's Corp, CORP, use that. If it's corporation, use that. Don't shorten it. If they're using corporation, don't say Corp. It needs to mirror the Secretary of State records precisely, including the punctuation. So if it's ABC Corporation, that's different than ABC, comma, Corporation, or ABC, comma, Corp. You want to make sure that those are accurate and that they're consistent across all of your documents. You need to always, the Franchise Tax Board suspension stops deals. Again, that's without a doubt one of the things we see as a consistent thing that stops deals. So you need to verify that they're an active corporation in good standing before parties sign anything. And the third, property tax reassessment can be triggered by a change in control of ownership of a corporation that owns real property. That's a tax and a legal issue. And you should flag it as such for either tax counsel or legal counsel to take a look at. Stay away from that. I tell people all the time, the way that agents get themselves in the most trouble is by stepping outside the bounds of what they do. Even we as lawyers, if it's we get into an area that we just don't specialize in, we're going to either in our case, we would basically either associate in some type of counsel that can then act as the expert on that specific area that we are not expert in, or we would refer it out, but we don't do work that's outside of our scope. That's how people get sued. So be very careful with that. Make sure that you do turn that out. Notary and recording, make sure that the officer's capacity is clear on the face of any recordable document, and ask title if they need any entity affidavits or endorsements. So corporate structures can be layered. Often a special purpose subsidiary would hold title while a parent corporation would sign a guarantee. And in those cases, you need a resolution from the title holding corporation approving the transaction and naming the signing officer, plus a separate parent resolution authorizing any guarantee. A secretary's certificate should attach the resolutions and confirm the current officers of the corporation. So keep signatures simple on the page, but make sure that the chain of authority is complete in the escrow package. Here's the authority packet that I would recommend sending early to title. One is a board resolution and a unanimous consent for the transaction. Second would be a secretary's certificate confirming the officers and attaching their resolution. You're also going to want to make sure that you have a copy of their statement of information showing who those people are. That can be done through the Secretary of State printout. Good standing certificates, a copy of the bylaws, and then if there's a foreign corporation, proof of the California qualification and a proof of home state good standing. So, for instance, if it's a Delaware corporation, make sure that they're registered to do business in California and that they are in good standing in both their home state and California. So before anything goes out for signature, make sure you do a quick signature block check. Does the corporate name exactly match the Secretary of State record? Does the signer's title match the either the incumbency certificate or the statement of information? If the bylaws require two signatures, are they both present? If not, do you have a board resolution authorizing a single officer to sign? And then are the names and titles used consistently across the letter of intent, which you probably would have, the purchase agreement or lease, the escrow instructions, and any recordable documents? Now, it's a quick 5-minute check that could save you days at the closing and make sure that you get paid in a timely manner for your work. So let me summarize the most common pitfalls and how to avoid them. Pitfall 1 would be contract signed by someone with the wrong title. Avoid it by obtaining a current secretary certificate and a board resolution that names the signer. Pitfall 2 would be the wrong corporate name in the purchase agreement or deed. You can avoid that by copying the exact Secretary of State name, including the suffix and the punctuation. The third pitfall would be missing internal approvals until late in escrow. And again, how you avoid that is you would make the board resolution or the secretary certificate an early deliverable and a condition to either opening or closing escrow. The fourth pitfall would be a foreign corporation not qualified in California. You should avoid that by requiring certification and proof of good standing as a closing condition. And then the fifth is the franchise tax board suspension discovered at the 11th hour. This delays more deals than I can begin to tell you. You avoid that by checking status on day one, and you check it again before signing. Make sure that these guys are staying accurately up to speed on where they are. So the key takeaways from all this stuff about corporations would be: first, verify corporate identity and status. Don't ever assume. 2, get a transaction-specific board resolution and a secretary's or an incumbency certificate. 3 would be to align the names, titles, and signature blocks across all documents. 4th would be to pre-clear the authority packet with title and escrow. If you do these 4 things, they will definitely operate to keep deals on track and protect your commission. So again, I'm Todd Frahm with Tyler Law. We assist clients across the full life cycle of real estate and business matters. Our practice includes real estate, corporate, LLC law, general business matters, employment, estate planning, probate, trademark, and general civil litigation. So if either you or your clients need help with entity authority, transactions, contract drafting, disputes, planning, we're here to help. Feel free to contact us at 951-600-2733. Again, it's Tyler Law, LLP, at 951-600-2733. And I wish you the best of luck on your deals and hope that we can work with you at some point in the future.